All right, class, we'll be starting very soon. And I'm a little bit under the weather, and a few of you know that. Those of you that don't know that, that's okay too. I'm going to have a little sip of iced tea. And we'll be sharing a little bit in class. We're going to check, there's a few things we're going to do today or this evening. The first thing we're going to do is we're going to talk about the staples that we have on the Google Drive to benefit you as for your success in the real estate industry. We'll look at the things that are at your fingertips, and we'll look at a couple other things. And I actually need to record. All right, recording is in progress, everyone. For those of you that are on Twitch and are watching it on Twitch or are going to be watching it in the future, that's cool. And then we will have this uploaded to the YouTubes of it all at some point tomorrow. I did yesterday drop a video on explaining the terminology and the vocabulary for the courses. If you are with UCLA, if you are with Glendale Community College, or if you're at one of the campuses, hold the phone. Sugar Bear. Did you want to say hi to everyone? Okay, come on. Okay, okay. What do we say? We say hello. Who could it be out there, huh? Are you hearing people and things and stuff? It's okay. Yeah, we're gonna have class, okay? This is Miss Lovebug. Miss Lovebug. It's okay. Do you want to take her? It's okay. I think she's just because of me not being well. So let me switch back to what I was talking about. Actually, I don't remember what I was talking about. That's actually showing you the proof. Oh, thank you. I made a video yesterday explaining no matter what college you are at, or whether you're at a private institution that I'm teaching at, I'm teaching these contractual law courses at a number of different places. And they are all approved with the California Department of Real Estate based on the curriculum. I know that the books that you guys are working off of have a list of vocabulary terms. I'm not trying to hinder you from learning the terms and definitions in the book. I'm trying to add to that repertoire. Excuse me. We're having class, Bubba. So I might have to end early just because everything's a lot abnormal right now at the house. Not in a bad way, just things are different. Okay, so the video I dropped yesterday is associated with vocabulary. It's associated with how to do the vocabulary assignments and to be reviewing the vocabulary terms. There are 754 terms on the Department of Real Estate website. So I'm going to stop sharing this. Let's go to the Department of Real Estate website so I can show you the glossary of terms. All right, so we're going to go do that. I'm going to share the screen. I'm going to be sharing a few things with you. So if we go into DRE, dre.ca.gov, glossary of terms. And this is what I shared yesterday, but I want to do a little bit of a recap. It will say 27. So on the California Department of Real Estate website, they actually have a book, and just kind of to share with you what's going to be on the state exam, whether brokers or salesperson. The 27th chapter of the book is the glossary of terms. There are 754 terms. There are a total of 34 and a half pages. I know that this says 36, but there's wonderful things about government agencies. And what happens usually is they will add a blank page. Page 36 happens to be technically page 36, but it's actually 596 is their 36th page of the glossary of terms. And then page 34, last page that has a full page, and then page 35 has half a page. That's why I say 34 and a half pages. There are 754 vocabulary terms. These are the terms and definitions that the questions are based off of. So if you understand the term and definition per the Department of Real Estate, you're going to have power. This is a powerful tool to have in your hand. They're the ones that write the state exam. Since they write the state exam, why not use their book? Why not use their glossary of terms? Well, their book doesn't detail like the books in the curriculum that you have. Those have been done by professionals who know the industry for the state of California. And those books and that curriculum, as well as the syllabi, have been approved by the Department of Real Estate. And that's associated with the Senate Bill 1495 that just came it came out in 2022, but requiring us to have these changes for 2024 for the practice class. But the terms aren't going to change. In the same way, if you take any of the classes you're taking with me, you could be taking property management, you could be taking practice principles, legal aspects, econ. I'm trying to think of some of the other classes that I'm teaching over the course of the next couple semesters. Any of those courses, the term and definition or the terms and definitions that are going to be used in all of those are associated with contractual law in the state of California. So let's just go to where they're writing the state exams, to where the contracts, like, so for as an example, the California Association of Realtors CAR forms or the ZIP forms, depending upon what you guys want to call them in the in real estate, those forms are associated with these terms, and they deliberately will use these terms and these definitions in those contracts, disclosures, all of the things associated with ZIP, right? Or all the things that are associated with California Association of Realtors or CAR, or the CAR forms or the ZIP forms. So I want to give you this. I'm not going to test you on the vocabulary in the book. The vocabulary in the book is great. I know at least one set of the curriculum. I actually know the executive editor, wonderful, wonderful person, amazing. And I know that they do everything they can to get it as close as they possibly can to exactly what the Department of Real Estate is testing you on, because they want you to, they want you to be successful, right? So they're not going to mix a bunch of, my mom would say, mumbo jumbo in the mix of all of it. And I'm not going to do that either. So as your instructor for these classes, even though the majority of your classes, unless it's lecture based, if you're with me for 6.5 hours twice a week, God bless you for staying awake through me talking to you. But if you're in these independent courses, I give everybody the exact same list. I give everybody the exact same 754 vocabulary terms to have, so that you are available for any question that could be asked of you. There are 13 classes, and out of those 13 classes, only 2 of them are required by the California Department of Real Estate. The rest of those classes are given, you get to choose. If you're in my my course for legal aspects or real estate law, those courses are associated with the legal aspects of every aspect of the industry, and even the parts that we don't do. Why? Because we walk hand in hand with other agents. We walk hand in hand with them, and the agent could be the escrow agent, the agent could be the loan originator, the agent, these agencies or these companies out there that we're working with. So this legal aspects class is going to hit all of those. Whereas if you only take a class on escrow, escrow is great to know that that's the neutral third party and what the job and the process is, but it's going to hyper focus on that and not necessarily on all of the aspects. That's why I teach the legal aspects class, and that's why it's really important. The key to knowing these 754 terms is that no matter what you're asked, if you're asked any of those things, but and there are words here that you haven't heard, whether you've been in my classes or you've been in another instructor's classes, whether you've heard those terms or not, those terms are here. And out of the three, and we calculated this, what, like 2 or 3 weeks ago? And out of the 300 questions you could be asked, out of those 300 questions, they have 4 options for you to answer. And so you could be asked, you won't be, I don't, and if you are, I owe you a cup of coffee. You won't be asked about every single one of the 754 terms. But what if you were? I want to give you every opportunity, every potential possibility that could be handed to you so that you can successfully pass the state exam the first time. Are we going to be the 52, 53% that pass the first time? And I know you can be. And I believe in you. And I've had students that that have called me and apologized for not passing. Look, passing a state exam isn't just the knowledge. It's the did you sleep the night before? It's do you have any family concerns? Are there any family emergencies? Were you almost in a car accident on the way to get there? There's so many things that go into taking a state exam or any exam. But I know that you can do it, and I do believe in you. And if you feel like, oh, I've let you down, I didn't pass the first time, I don't want you to feel that way at all. Why? Because I didn't pass the first time, and my brothers are in the industry, and I had to do the walk of shame in front of them, and go, and they're like, we can't believe you didn't pass the first time, you know, and all the things that siblings say to each other. And of course, I responded in the same manner, or reacted in the same way. But the reality of the situation is, I thought I was there. I mentally thought I could do it. I mentally thought I was there, but there were some terms that came up in the exam that I'd never heard before. And then I was told, oh, well, you don't really get, your prerequisites don't really cover everything that you could be asked on the state exam. And I was like, wait a second, I was robbed. I paid for all that money. They said that they guaranteed that I'd pass, you know, like all the stuff that people say when they advertise to get you to take their classes. These are the 754 terms. These are the terms I want you to know. These are the terms I want you to work on and focus on. You need to answer the questions in the book. You need to review some of the vocabulary in the book and see if it's any different than this. And if it's not, then do whatever you feel best that is best for you. But the way the exam is going to be written is going to be based on the way the term is written in Chapter 27 of the Glossary of Terms for the Department of Real Estate. So I want you guys to be focused on this. And how do I help you with that? Well, I started a glossary of terms and images in the Google Drive that I have for all my students, past, present, and kind of not for future students, but future students can be privy to the videos. And then what will happen is you can be part of the course, and then I can send you this information. But this is the start of the glossary for the Department of Real Estate for California. But this, as you can see, is for letter A, okay? So letter A, abandonment, the failure to occupy and use property that may result in the loss of rights. This image gives me the feeling that this property was abandoned. And obviously whoever, now this says it was left by the tenant, but the reality of the situation is whether it was the tenant or the owner, this property was abandoned. They walked away from it. And you can see from a tenant's perspective, if the tenant leaves, the tenant did not take any of their things with them. Abatement of nuisance, extinction or termination of a nuisance. It's easy, right? Who is the nuisance? Well, if your neighbor likes to listen to AC/DC at level 11, then you're not a huge AC/DC fan, you could consider that to be a nuisance, right? And if it's after, let's say you have a mandated sound ordinance of like 10 p.m. If they don't follow that 10 p.m. ordinance, the local powers that be will be called and they will break up the party or whatever the situation. And there will be a note. And the thing about it is there will be an abatement process started, meaning that if they are a tenant and they are not the owner of said property, the owner of the property is going to hear from the city or from the powers, right? The powers that be, that their tenant is not following the local ordinance, and of course everything with due process, but the nuisance will be taken care of. Absolute ownership, fee simple estate. This image is a great one because the house is yours, the ground, the soil under the house, and then the air rights above your property. This is called fee simple estate. The greatest interest that one can have in real estate, an estate that is unqualified, of indefinite duration, freely transferable, and inheritable. And when they say it's unqualified, what they mean is you don't have to meet certain criteria for you to have fee simple estate. You just have it. But if the property's transferred to you by your grandfather and your grandfather says that I will transfer, that this property is being granted to you, but there is some type of clause, there's some type of restriction, you do not have fee simple estate. You have an estate, but there are qualifications for that. And we'll talk more about that term in just a moment, okay? What about abstract of judgment? A condensation of the essential provisions of a court judgment. So what is it? That's the determination. So an abstract of judgment means that we've already gone to court, right? And we're in a position where we were found to have not followed the law. Now there's a determination. Now there's something that we need to do. We might need to pay for this. We might need to pay for it in many ways. We might lose our license and the like. So abstract of judgment, the condensation of the essential provisions of a court judgment. If you look at it from the perspective that it's a determination, the court has now judged. The court now has this abstract of judgment, meaning, okay, this is how we found this, and this is how this is what was determined. And now the person that has been found, or people that have been found guilty, will have to follow this. And the people that won, hopefully they will actually get paid. What about abstract of title? A summary or digest of all transfers, conveyances, legal proceeds, and any other facts relied on as evidence of title, showing continuity of ownership, together with any other elements of record which may impair title. So abstract of title. I love this image. It's explaining it. So the summary, so this is basically the summary or the history of the property, right? And the past happenings, meaning all of that gets accumulated. So who owned the property originally? So now we have a chain of title, if you will. So the very first owner sold it to the next owner, sold it to the next owner, and so on and so forth. And it's associated with said property. And now, who owns it now? This property is owned by Kathleen and Adam, and we have a first mortgage on the property, but we did not purchase or acquire this property until December of 2022. So a summary or digest of all transfers, conveyances, and legal proceeds, meaning from the very first person all the way down to us. This abstract of title is giving details, the history, if you will. What about abstraction? A method of valuing land. The indicated value of the improvement is deducted from the sales price. This is like one of those images that's a before and after. I really like it. They definitely did a lot of work to said property. They kept the chimney, but everything else, you can see that they have added additional square footage. So how do they value this property? Now, I know it says the valuing of land, but real property or real estate is land and then all of the improvements on it. So in this situation, the method of valuing the land, so what's the value of the land? And then the indicated value of the improvements would be deducted from the sale. So they would bring in the value of the land, the house prior, and then the house after the additions. Accelerated cost recovery system. So when we talk about the accelerated cost recovery system, we're talking about how we're basically saying the moment you see anything that says cost recovery system, it's like, oh, this is for investment. So if you're going to go into commercial real estate, or you're going to work with a investor that has lots of investments in different types of real estate or different types of building, whether it's buildings or residential, whether it's commercial residential, whether it's 1 to 4 single family residences, they're going to talk to you, or they're going to want you to know or be slightly familiar with the accelerated cost recovery system. Now, as a realtor in the state of California, in order for you to talk shop with regards to like money and crunching numbers and things on the commercial side, that makes complete sense, right? But on the residential 1 to 4 unit side of things, you're going to need to go get your multiple listing, or excuse me, it's NMLS, National Mortgage LS. I'm sorry, I don't know what the abbreviation stands for. That's an additional set of prerequisite courses. That's a national exam. Once you've passed that NMLS, then you go and you submit that information to the Department of Real Estate, and then the Department of Real Estate, as a licensed real estate agent, will go, oh, okay, now you can do real estate, list it, sell it, and you can also do loan origination. So this accelerated cost recovery system would be something that you'd be doing on the financial side of things, more commercial than anything else, but it would be on that. So accelerated cost recovery system is the system for figuring depreciation for depreciable real property acquired and placed into service after the 1st of January of 1981, and that's associated with the ACRS, which is actually Accelerated Cost Real Estate System, is ACRS. Now, how do we figure this? How do we go through this process of figuring out the depreciation? There's all kinds of programs for that. I don't personally do this side of real estate. So if you are interested in knowing how to present accelerated cost recovery system, I would encourage you to reach out to companies like Eve Capital. They're here in Southern California in Venice. Amazing owner. I've had her in one of my classes at UCLA to visit with the students and just talk through the process of being a commercial real estate agent. There's number crunching. There's a lot that goes on to being a commercial real estate agent. And before going into commercial real estate, I want you to interview at least 5 brokers, and I want one of those to be Eve Capital because they do things completely different than anyone else. And I'm sure you guys hear that all the time, but they're not sponsoring this video. This is a class. But the mindset is different. And when it comes to commercial, it's very dog eat dog. And I want you to talk to a company that's not got a swinging door policy. And what I mean by that is they're really wanting to encourage you to build your clientele and be trained in how to keep clients, how to recover clients, how to recover situations, and just continue to bring in business. And you're not necessarily going to find that with a lot of commercial companies, but I know for sure that this is something that they do because they're in it for the long haul or the long term. Accelerated depreciation, a method. Now we just did accelerated cost recovery system. Now this is accelerated depreciation. This is a method of cost write-off in which depreciation allowances are greater in the first few years of ownership than in the subsequent years. And how are we going to know what that cost write-off is? Well, you're going to find me saying this a lot in class. I am not an accountant and I am not a numbers person. I am kind of a numbers person, but I'm not a numbers person in this field. Why? Excuse me, I got the hiccups. Why? Because I'm a realtor, and my hat that I'm always going to have in class with you is being a realtor, being a real estate agent, being a licensed real estate agent for the California Department of Real Estate. I'm not an accountant. I'm not a tax person. I'm not somebody that can talk to you about cost write-offs, but I know that Eve Capital can go through that with your clients, especially on that commercial side. This accelerated depreciation, we can go term and definition. I like to be able to break it up in this manner to kind of balance out why would we be talking about this or why should we know about it? Because our clients, if they're looking to buy a particular piece of land and we're helping out with the contract, whether it's for them to buy, we're putting in the offer, whether it's for them, maybe it's a lease, maybe you're going to do property management. There's a number of things out there that you could be doing with the client. And even if you choose not to work with them on the commercial side, it's good for you to know a commercial real estate agent. It's good for you to know a company out there that has a very good customer service base because you're not necessarily going to find that. We know that, right? How many of you in class are going, oh, yeah, I know a couple of real estate agents that are no good? Almost everybody knows someone that's bad, and sometimes we're harder pressed, or people that we know are hard pressed to find a good agent. But you guys are in my class and you guys are powerhouses, okay? So I know you're going to be a good agent. Accelerated depreciation is a method of cost write-off in which the depreciation allowances are greater in the first few years. Term definition. What about an acceleration clause? This is something that you're going to see paperwork for, and it might make you a little nervous, but you shouldn't. This is a condition in a real estate financing instrument giving the lender the power to declare all sums owing lender immediately due and payable upon the happening of a specific event. And what would those events be? Well, the sale of the property or delinquency, meaning they're going to foreclose, right? And so in class, you might hear me, or in some of the instructions you might be reading by me, when we talk about acceleration clauses, there's a form and it says acceleration clause at the top, or it'll say demand. It's a paid, it's a demand for payment, and it says demand for payment. And you're like, what did my client do? Well, technically speaking, they promised that they would keep that mortgage for 30 years, and it's been 20 and they're selling the house. And so what happens is the escrow, neutral third party, reaches out to the lender and says, hey, John and Jane Doe are going to sell their home as of, what's today's date? Oh, I don't have my phone with me. That's okay. Oh, today's November 1st. I apologize. So as of November, they wouldn't do it last second, but they would say like, we're closing on November 10th. So they would reach out to the lender and say, as of November 10th, we will be closing on the sale. Please send us the payoff for the mortgage or the mortgages. Most companies only have one mortgage, because most companies, even if they have a second mortgage, it's a completely different part of their company at a completely different even state. Sometimes it seems like, but you'll literally have them send something and it's in bold at the top, acceleration clause, or it'll say payoff demand, and we require that you blah, blah, and if you read it like that, because it's easy to read it that way because that's how it's written. But the reality of the situation is they're being told right now that your clients are no longer going to be owning that property. They're basically going to be granting it to someone else for a fee, right? They're somebody else is buying it. They want to make sure that when they sell it to that next person, that they get paid off, because the people that own it right now, or are living in their best life in it right now, owe the mortgage company something. So acceleration clause. Acceptance. I should have made I'll fix the form. Sorry, guys. The act of agreeing or consenting to the terms of an offer, thereby establishing the air quote meeting of the minds that is an essential element of a contract. So when we accept a contract, that means we've signed on the dotted line, right? We're accepting the agreement, the bilateral contract between a seller and a buyer. You could even say your agency disclosure regarding your agency relationship with your clients is a contract. They are employing you to help them either sell their home or find their forever home. Access right. The right of an owner to have ingress and egress, going in and coming out to and from the owner's property over adjoining property. We actually have an access right to the property in front of us, and the people behind us have the access right through all of the properties to get to their home. This is give ingress and egress means you can come in and you can go out, but you're not parking. You're not going to have a barbecue. You can't put a pool in. This is just an entrance and an exit for you to go through the property. Usually access rights are associated with the fact that this is the only public road. They probably can't take the train and drop off. They probably don't have their own station. And even if they did, even if they did, if they don't travel by train, that's not going to help them, right? Sorry, guys, I do have the hiccups. And you can see here that there are not public roads on either side. All right, let's talk about water. Accession, an addition to property through the effort of man or natural forces. So this is a great image because it gives you the breakdown of accession, avulsion, and alluvium. And those are three words you do need to know the differences. Accession is the addition to property through the efforts of man or natural forces. So you could say on this island, this is accession, and based on what's happening here, the land, oh, Kathy, come. The land is being pushed over, and eventually there'll be more land here. Okay. Accretion, accession by nature for natural forces or alluvium. So now again, we have accretion, which is another example. All right, what about accrued depreciation? The difference between the cost of replacing new as of the date of the appraisal and the present appraised value. So accrued depreciation, the difference between the cost of replacement as of the date of the appraisal and the present appraised value. So you might find that accrued depreciation is something that maybe your home insurance would want. So they'll have an appraisal done on the property, and they're going to want to know what the difference is in replacing the property and what the value of the property is now, so that they can see if they want to insure it or not, because it might be upside down. You might have overbuilt for the area. So accrued items of expense, those incurred expenses which are not yet payable. So the seller's accrued expenses are credited to the purchaser in a closing statement. So let's see what this image says up here and see if we can get a better vocabulary definition. An accounting term that refers to an expense that is recognized on the books before it has been paid. So it's an IOU, accrued item expenses, those incurred expenses which are not yet paid, IOU, right? So it's like, I'm good for it. You know, I'm good for it. Let's take care of this. It's a form of an IOU, right? The seller's accrued expenses are credited to the purchaser in the closing statement. Acknowledgement. Well, let's talk a little bit about notary. A formal declaration made before an unauthorized person. Excuse me, it's authorized. I do this in class like all the time. A formal declaration made before an authorized person. Who's the authorized person? That would be the notary, the person that has the notary seal, right? The embossment. So a formal declaration made before an authorized person, a notary public, by a person who has executed an instrument, meaning signed on the dotted line. So it has to be executed. Notice there's no execution on this page, but that's part of the process. So in this state, an acknowledgement is the statement by an officer, such as a notary, that the signature or the signatory to the instrument is the person represented to be. And you're like, Kathy, that's all mush. I know it sounds a little bit like mashed potatoes, but put a little gravy, salt, and pepper on that, and we can get this. Basically, an acknowledgement is letting us know that the person who's, let's say, the grantor of the property is deeding the property to someone else. They are acknowledging, they are executing, actually, right? And with the notary being in the room with them, they have that acknowledgement. They have the notary acknowledging that the person that owns the property has granted it to the next person, and that acknowledgement is actually the proof that the notary saw them sign. Who's them? The grantor of the property. Are you doing okay? Yeah. Are you struggling tonight? Yeah. Come on. You can come here. There's a little room left on my lap. All right. So let's talk about acoustic tiles. And you're like, or acoustical tiles. You're like, why are we talking about acoustical tiles? Because this is a thing. They're blocks of fiber, mineral or metal, right? With small holes or rough texture surface to absorb sound, used as covering for interior walls and ceilings. You might find in a commercial property that there has been a sound studio, or we're in not all my students, but a lot of my students are in Southern California. The entertainment industry, you'll find that a lot of the warehouses that you go into look to lease, that the previous people that have been in there have built different types of sound studios. These acoustical tiles help with the balance of the sound, so it's not echoing off the walls or echoing in the room. But sometimes you can get away with stuff like we were old back in the day. We were old school when we did recordings and stuff. We'd put carpet on the walls and carpet on the floor, and then where the door to go into this, and we have these like little closets with a window, and then where the door, where you'd go in the door, they would have like a mattress and put a mattress up against the door so that no sound would even come out of the door and that kind of stuff. Old school. But acoustical tiles, you need to know what they are. What about acquisitions? The act or process by which a person procures property. You are acquiring the property. So you have, so I heard about your acquisition yesterday. You can sit right here with me. Come on. I heard about your acquisition yesterday. My acquisition. Yeah, I heard about. Oh, did you want the velvet side and not the fluffy side? Oh my gosh, you guys, she's hilarious. Come on, it's okay. It's okay. I know. Right here. We got a little bit of trauma drama going on in the house, so it's okay. So when someone says that that they just finished an acquisition, that's the active process, a process by which a person procures property. Oh, well, I did 4 acquisitions last week or whatever, and you're like, whatever. You do need to know what the term means. Okay. What about an acre? What's an acre? It's a measure of land equaling 160 square rods or 4,840 square yards or 43,560 square feet, or a tract about 208.71 feet square. Do you need to know the definition for an acre? Yes. Will you be asked on the state exam? Yes, you will definitely be asked on the state exam. What about actual authority? You're not my mother. I always think of that when I think of this term. Authority expressly given by the principal or given by law and not denied by the principal. So there is actual authority. It has been given by the principal. Who's the principal, Kathy? That's your client. Now, how are they your client? You've actually signed disclosures with them, like agency relationship. There's the disclosure regarding agency relationship and a number of other things. They're giving you actual authority to help them buy a home. The actual authority to list their property. What about actual fraud? I don't know if we really got to go there, but I think we know what fraud is. But let's see what the term and definition says. Okay, let's see the definition. An act intended to deceive another, making a false statement, making a promise without intending to perform on it, or suppressing the truth. And you'll find that there are a number of questions if you're studying through CompuCram or PrepAgent or the like. You might find that there are questions with regards to how an agent would handle a situation where they may know that the basement is flooded and be showing the property and say, oh, I don't have the key to the basement. That's suppressing the truth because they're not showing the basement is flooded, right? But that's a disclosure. It's not a disclosure. It's not the right word for it. Let me think of what the right word for it would be. Our fiduciary duty as real estate agents, we have to tell the truth about the property at any given time, anything new that we know about it. So it's technically suppressing the truth because we as the realtor showed the property and didn't share that the basement was flooded. And whether we had the key or not isn't um, as important as the moment we find out that the basement is flooded. That needs to be told to our potential buyers because they might go, if it's flooded today, it's going to definitely be flooded in the winter season. We're not even in the winter season. I don't know if we want to deal with, getting a home inspection or getting the type of inspection needed to fix that. So suppressing the truth, um, saying you're going to have the house painted if they buy the house and then the house isn't painted, and you never expected to paint the house, that kind of thing. Addendums are a thing with the contract, right? You've got your purchase contract, and then they're like, see addendum 1, and see as in look review, right? So addendums, an additional page of material that is added to become part of said contract. So there could be a situation, this is a good example of just, oh, it actually is just a sample of what it might look like. I don't know why you would have to put that it's a residential purchase agreement as the addendum, but a good example for an addendum might be something where we know it's already a purchase and the buyer has a roof inspection and the seller guarantees that there's a 2-year certification on the roof and it's good for 2 years. The buyer has the roof inspection done and goes up there. There's a massive hole, not them, the inspector goes up, there's a massive hole in the roof because an asteroid just blew in or something like that. So there would be an addendum to have the roof fixed and that would be something that would be fixed and paid for most likely by the seller because the seller has insurance. But those kind of addendums are things that come after they've already agreed on the contract. Usually an addendum comes in after an agreement has already been made. Adjustable rate mortgages, those are your arms, right? So one of the things I always tell my students or ask my students to do is raise your arm and don't move it for the rest of class. And that sounds like a weird thing to say, but when your client gets an adjustable rate mortgage, this is the best example of how I can express how adjustable rate mortgages work. An adjustable rate mortgage is a mortgage loan which bears interest at a rate subject to change during the term of the loan. It's predetermined. It could be predetermined or otherwise. Now, what they mean by otherwise is the rate can go up or the rate can go down when it adjusts. But the truth of the matter is the rate is not going to stay steady. On a 30-year fixed, you don't have to raise your arm because we already know it's fixed for 30 years, right? But on an adjustable rate mortgage, the arm, if you will, the adjustable rate mortgage will be fixed for 2 years, 3 years, 7 years, 5 years, whatever the situation. Under adjustments, in appraising, so when we talk about adjustments, we're not saying like adjust your shirt or adjust your hat. When we're talking about adjustments, we're talking about appraisal. You'll see that there's the subject property, and we're going to find comparables. So we have comp 1 and comp 2, and both of these comparables are going to adjust to reflect how they are like or how they're not like the subject property. So let's see what the term and definition says from the DRE. In appraising, it means by which characteristics of a residential property are regulated by dollar amounts or percentages to conform to similar characteristics of another residential property. So they're being compared to the subject property, but it's never vice versa. And you might get a question on the state exam asking you to answer which property gets adjusted or where do the adjustments come in? Well, the adjustments come in on the comparables, not on the subject property. We're trying to find for the value of the subject property, like properties. Is it a 4-bedroom? Is it a 2-bathroom? Is it a 3,000 square foot house? When we get to the end of this list, I'm definitely going to have to go. But if you have any questions, put them in the chat and we'll go from there, okay? What about an administrator? Who's an administrator? It's a person appointed to the probate court to administer the estate of the deceased person who died intestate. If you have died intestate, meaning if you have been buried into the ground without a will, you've died intestate. That's what they're talking about. An administratrix would be the feminine. Administrator, administratrix, you can use either of those when you're looking at the word administrator, because it does the exact same thing. So basically what this means is an administrator is somebody that the judge has gone, hey, we don't have a will for that property, so I need somebody in our office to administrate, whether it's the administratrix or the administrator, whether it's male or female. I need them to take care of dissolving this problem or alienating this concern, or I'm trying to think of some of the other terms we use in class. Disposing, thank you. Disposing of the property, meaning it needs to be sold. Good job, guys. ADR, alternative dispute resolution. So this is the resolution of disputes by various means that are included but are not limited to negotiations, mediation, and arbitration. In our listing agreement and in our purchase agreement, joint escrow instructions, and all of the other contracts that are out there, there must be information about dispute resolution. And per the CAR forms, yeah, we'll fix the image. I thought I had already fixed all these before we came to class today, but I do apologize, guys. Let me just check something. I might need to go a little sooner than I expected. And you haven't asked any questions, and no questions are always good with me. You know me, we'll fix the formatting. I'm not that worried about it. But dispute resolution is the thing. Now, what you need to know the difference between mediation and arbitration. Mediation is where you go into a room and you say, this person hurt my feelings because they sold me a house that has walls. The walls are blue, and they told me they're going to paint them purple or whatever. And mediation is trying to come to a meeting of the minds. Arbitration is just the facts, ma'am. Here's the contract. This is what the contract says. You didn't follow it. You as in the proverbial you. I'm pointing this way. Not trying to point at the camera. Not you, the proverbial you. You didn't follow the contract, so you've been found guilty of not following the contract. The contract is going to hold up in the court of law. Why? Because statute of frauds, right? It can be held up in a court of law. If you're in class with me and we do the lecture, you'll hear me say, hey, you got to have your receipts. You got to have your CVS receipts. Or you'll hear me say, if it doesn't hold up, if you can't hold it up in a court of law, it's not going to work, right? It has to be in writing. Ad valorem. What is ad valorem? That's your property tax, right? It's the Latin phrase according to the value. So according to the value, that would be your ad valorem tax, usually used in connection with real estate taxation. So in the state of California, you have ad valorem tax. You've got your standard run-of-the-mill 1% of the according to value of the property. The assessor is going to go, hey, we just noticed that your house is worth $1.4 million. So we're taxing you for that because you bought it for well, 1.3999 or whatever the situation, and they can't exceed your tax base by more than 2% a year. But if you just bought the property, now we bought this property last year, and they were like, "Oh, hey, we see that you paid less for it than you expected, but we think the house is worth more, so we're not going to go off of what you paid for it. We're going to go off of what we know the values are in the area if you were to turn around and sell it." And it's humorous because it's like, well, if they could sell it for that, they could have been able to. But basically, according to the value, the tax assessor can say that we see the value here, not there. And they did that, and they can do that. And we're going to end on advance transfer of funds from a lender to a borrower in advance. So in advance on a loan. Sometimes you'll like watch a movie or something and you'll hear somebody got an advance on a book. Britney Spears' book just came out, and I think she got a $12 million advance on the book or something like that. And so it's already surpassed the advance. I read that somewhere, which was really cool. Within the first day, they had already recouped the advance that they'd given her. But advance transfer of funds from a lender to a borrower in advance of a loan. Now, that's her book situation is not the same as this, but I want you guys to be able to balance out some of the other ways that the word advance can be used, and then itemize it and collect that for this class and for the state exam and this industry. Advance commitment. So the institutional, let's see what the term and definition says. The institutional investor's prior agreement to provide long-term financing upon completion of construction, also known as a takeout loan commitment. So advance commitment. So what is that? That's where, let's say you have a piece of land and you have a company that's going to build the house. So you have a construction loan. Now, what usually happens when you have a construction loan is that there is a lending institution that says, "Hey, we're looking at the blueprints, we're looking at the land, we're looking at all these things. Once they're all built to spec, right? They're built exactly like it says. We're going to give you an advance commitment saying in 2 years when this is done, we will buy that construction loan and give you a mortgage loan for it." So you could consider it also a takeout loan. So an advance commitment. You're promising ahead of time, "Hey, man, that looks like a great property, and everything's staying the way it is, and and that we don't go over on costs and things." Now, an advance commitment would be hard pressed. You'd be hard pressed to follow up with it after the pandemic or during the pandemic, right? Because we had the port issues, and we had wood that wasn't able to come in, and we had all the things that were going on during the port concerns. So the price of wood was 3 times as high, and instead of 2x4s there was only 2x3s, and just like these crazy things were happening during that period of time in this industry being construction. For those of you that are like, "Kathy, I don't want to work with anyone that's doing construction loans," you don't have to work with them, but you need to be familiar with the terms. What about advance payment? A fee paid in advance of any services rendered, sometimes unlawfully charged in connection with that illegal practice of obtaining a fee in advance for the advertising of a property or business for sale. So we've got to be careful, right? Are we charging ahead of time for something? Is it legal? Well, if it is legal, I want you to go talk to your broker. I want whoever your broker is, you hire your broker. Your broker thinks they hire you. I've talked to you guys about this a few different times, and I'm going to keep saying it. Whichever broker you feel really comfortable with, ask them, "Do we have any advance fees? Do we charge anything before it closes? If we do, how do we handle that? How is this handled in our office?" Your broker didn't just fall off the turnip truck yesterday. And if he did, don't go to that broker. If they did, don't go to that broker. But they didn't. And because they didn't, they're going to go, "Oh yeah, advance fees. This is how we disclose this information. This is the disclosure that we share with them, that we will do the following things as long as this closes. And if it doesn't, or however they want to handle it." Hold on just a second. Sorry, Bubba. Hold on. Excuse me, you guys. I'm so sorry. I'm sneezing and I'm doing all the things. What about adverse possession? Adverse possession, a method of acquiring title to real property through possession of the property for a statutory period under certain conditions by a person other than the owner. It's got to be 5 years, and there are 6 things they have to do. And one of the things they have to do is put in a piece of, if you want to live off the land, you can, but you have to put basically a home, a cabin, a fence around your space. You've got to physically make it viewable by everybody, including the owner of the property. So if you know anybody that owns, like, I don't know, 20,000 acres in Montana or somewhere else, there could be thousands of acres in California, or hundreds or even a few acres in California, but it's wooded, and you don't know where the property lines are, or your client doesn't know where the property lines are, they need to go walk their property line and make sure that nobody is sitting on their property and then paying the property taxes. Because over the course of 5 years, if the property taxes are being paid by this person that's just, squatting on the property, and they can prove that they've been living there and paying the taxes out of their own money, that's how adverse possession works. We talk about this in length in one of my classes, and people were like, how could that even work? Well, you could say that, let's say your neighbor is an elderly person and you've been helping your neighbor out. And then your brother's like, oh, I'll help him out too. And so you and your brother are helping, but then your parents become unwell, and you're taking care of your parents, and your brother takes full responsibility to take care of this elderly person that lives next door to you. And then that elderly person that lives next door to you is moved into hospice, and they don't have any children and they don't have any heirs. And you're like, what do I do? And they're like, you know, um, I just need to get well, but I'll be back. And you're like, okay, but the bills aren't paid and the taxes aren't paid, and they're in not hospice, but they're in a home for more than 5 years. If you've been paying the taxes, now you could say, well, the owner of the property would have known that you were living in the property. They may not. So those kind of things, adverse possession could work in that kind of a situation. I'm not asking you guys to go look for elderly neighbors and do something like this, but adverse possession could happen. And I did have a student that shared that their brother did do something along those lines, but it didn't realize, they like started paying the taxes, didn't know what was happening. And then when it was all said and done, it was like, you know, there was nobody to take the property. And he, like, how do I Googled it and found out that he could take the property for it by adverse possession, because if the homeowner had come back, the homeowner didn't give him permission to live there. The homeowner didn't give him permission to pay the taxes. The homeowner didn't give him all of the things. There's six, and we can talk about that. Or actually, you're going to read about it in the book, and then you can tell me about it in one of the class assignments. What's an affiant? One who makes an affidavit or gives evidence. You could say that the notary is an affiant, right? In an affidavit, the affiant is the person swearing that the statements contained in the affidavit are true. What's an affidavit then, Kathy? Well, it's a statement of declaration reduced to writing, sworn to or affirmed before some officer who has authority to administer an oath of affirmation. Now, a notary has the authority to administer an oath of affirmation. And how do we know that? Because when you go and you get your notary, then when you go through the process of your LiveScan and going to the state and making sure you have all your paperwork in, they will swear you in. And basically what the notary is doing is saying that I will be, that I'm working for the state, and that I'm protecting the state, and that anything that could hinder the state from being a stronger state, that I won't like notarize stuff. The people that are in front of me, or excuse me, the notarized documents that I'm going to, the affidavits, if you will, right, in front, that I will be signing, will be with the person standing in front of me, and that I won't falsify any of this information. Like hey, can you just sign off on it? My dad died and he really meant to, that kind of stuff. It puts you in a position where you're like, oh gosh, the state's going to come after me for this. Yes, they will. Um, affidavit of title. A statement in writing made under oath by seller or grantor, acknowledged before the notary. Okay, we already covered all that, right? In which an affiant identifies themselves and their marital status, certifying that since the examination of the title on the contract date, there are no judgments, bankruptcies, or divorces, no unrecorded deeds, contracts, unpaid repairs, or improvements or defects of title known to affiant, and that affiant is in possession of the property. So an affidavit of title, they're basically just saying, I own the property, or we as a married couple own the property, and nothing's changed. Affirm, to affirm, to aver, to ratify, to verify, to make a declaration. So they're to affirm. So you're signing this paper, right? And this is the California self-proving affirmation. You're basically saying, I'm well aware of what I'm signing. I'm not just signing my name off and just hoping that whatever we're signing is fine. You're affirming the information that's come before the affirmation. Agency. We talked about agency, what, 20 minutes ago? The relationship between principal and the principal's agent, which arises out of the contract, either expressed or implied, written or oral. But we know in the state of California, it's got to be in writing, right? To hold up in a court of law, it has to be in writing because you got to have your CVS receipts, y'all. Wherein the agent is employed by the principal to do certain acts dealing with a third party. So who is the third party? It's the people on the other side of the table. If we are helping our client or our principal list their home and sell it, and the procuring cause or the buyer's representation, I'm sorry, guys, the terms and the words are not coming to me right now. The third party is the buyer's agent and the buyer. So the relationship, so agency, we are the agents for the seller, seller. We are the agents for the seller. We are helping the seller list their property. We are the listing agent, or our broker's the agent. We're the subagents, right? Now, the third party would be the procuring cause, or the person bringing in the buyer, or the buyer's representative would be the buyer's agent. So that third party is, I always talk about them as, or you'll see me like go, they're on the other side of the table. They're working with their client, or they're working with their agent. Who's an agent? That's the one who acts for and with authority for another, called a principal. Now, I know that's the term and definition, but you're going to be asked on the state exam, who's the agent? And you're going to have to answer the broker, because the broker's license, we hang our, let me see if I can do this way. The broker's license, we hang our license as sales agents under the broker's license, right? The agent is the broker. We are the sub-agent. We are representing the brokerage and the client. But for term and definition use here with the DRE, the agent is the one who acts for and with authority from another, called the principal. Our brokerage has been given the authority to list and sell this home. And it would be nice if we can get a dual agency out of that, right? We could be on both sides of the table, if you will. Agreement of sale. A written agreement or contract between the seller and the purchaser in which they reach a meeting of the minds on the terms and conditions of the sale. So the parties concur. We concur, right? We're a meeting of the minds. We are in harmonious opinion. So agreement of sale. What about air rights? This is a great image. In the state of California, if you see these orange flags above a property, and a lot of times you'll see them on above a garage or someone's property, or on the side of their house. And the reason for that is anybody that lives behind this property that has that view, chances are they're not going to be okay with that happening. And what happens is the people that live on this property might not have the right to build all the way up without getting the permission of their neighbors. So what are air rights? Those are the rights on real property, or in real property, to the reasonable use of the airspace above the surface of the land. And you might find in the county that you live in that you can, and you have the right to 30 feet above the ground based on wherever you're living. I know that that's in Alameda County. We read that in one of our classes, that in Alameda County, your air rights go to 30 feet. That doesn't mean you can build to 30 feet, but that you have to 30 feet. And I would venture to say you can build to 29 and a half or something like that. I'm not sure though. What about alienation? It's another way of removing a property from yourself, or the right to the property, right? The transferring of a property to another, the transfer of property and possession of lands or land, things from one person to another. But alienation, because we're doing real estate courses, contractual law, it's the absolute sale. And that's what I love about this image. It's the absolute sale. We are alienating ourselves. Adam, I sell this property. We can't just come back and go, we just want to, stay for the weekend. No. We have now alienated ourselves from this property. What's an alienation clause then, Kathy? Well, it's a clause in a contract giving the lender certain rights in the event of a sale or other transfer of a mortgaged property. Let's see what the image says. Alienation clause gives lenders right to accelerated loan if the borrower sells security, property, or transfers an interest. So an alienation clause in this respect, they're talking about in your loan documents. Let's say you buy a property and there's an alienation clause in there. And in that alienation clause, you're like, oh, it's okay. The lender won't mind that I added my son to title, or I granted the property over to my son. What will happen is a copy of your alienation clause will be sent back to you, or something like a due on sale clause that says, hey, if you don't take this person's name off of this property ASAP, we are going to immediately foreclose, because in your loan documents, the moment you alienate yourself or remove yourself from the property that you have the loan on, we need to sell that property, or we need to make sure that you're selling that property. So we're going to give you the right to either get your son's name off of the title, or we are going to remove you and basically have the property taken from you and then foreclosed on. But a lot of times with alienation clauses, you'll find that the lender's like, hey, you probably didn't know what it was that you signed, but your son can't be on title, so you got to remove him, or we're going to have to foreclose on the property because you're in breach of contract with us for the loan that you got, the mortgage you got. So allodial tenure, probably saying this wrong, a real property owner's system where ownership may be complete except for those rights held by government. You might have a piece of property where the government has the right to oil or something else. I don't have the right image here though. Oh, because we weren't supposed to go there. Okay, we'll come back to this. It has been fun. Does anyone have any questions? And this is just a small snippet of the vocabulary terms. I wanted to be able to give you images to go along with the terms. Some of you are like, Kathy, we aren't even in the letter A. We're in the letter G in my class. Okay, we'll get to G eventually. All right. Okay, while you guys are thinking about it, let's do this. Let's go and look current processing times for the state exam. Let's see if we have any date changes. I'm having some click through. Sorry, guys. Well, hopefully it doesn't kick me out of class. Sometimes this happens, right? All right. So as of October 30th, they're currently processing applications from October 13th if you're just doing the state exam. And if you have applied for the combo as of October 30th, they're processing, oh, wow, combo applications as of October 4th. So before we get off, I need to say to you, if you are worried and you do not want to submit the paperwork before the end of the year because you don't want to take the state exam, submitting the paperwork and the state exam are apples and oranges, okay? Submitting your paperwork, you must, because you took your practice course this year, and this the Senate Bill 1495 will be in place as of January 1st, meaning you'll have to take one of your prerequisite required courses, the practice course, again. Now you're going to also have to find a company that is approved with the Department of Real Estate, okay? Now we're approved. I don't want it to sound like we're not approved. Every place that I teach at is approved. We've already been approved with the Department of Real Estate. But the concern I want to give you is you are going to have to go through another class. Let's not do that. Submit your application, submit your transcripts, submit your certifications, whatever it is, depending upon which school you go to, however they want to handle that, okay? Once they've received that information, they're going to send you an email that says, hey, we got your information, you're cooking with gas. When would you like to take the exam? Then, so that's apples and this is oranges, right? So you did the application. It's in your hand or your hands when you would like to take the exam. And you can say, you know what, I don't want to take it until January 2nd. Because you submitted your application, because you submitted your credentials, your transcripts, and they were approved, they will grandfather them into next year. You don't have to take the state exam by the end of this year. You don't have to set your date by the end of this year. They have to approve your application. So please get your application in as soon as possible, or just come back to class with me and we'll take a practice together. All right? I hope you are all well. We are. We're going to just claim that here. And I will see you guys soon. All right? I'm a text message away, Google Voice text message away. I'm an email away. Those of you that are taking your final this week, I believe in you. It's open book. As a reminder, take notes on the questions you get wrong so you can go back and review and study. That'll give you the strength in that area. Wherever we feel the weakest, that's going to be our strength for the next step in our real estate career, in our lives in general. When a weakness is found, we don't baby the weakness, we strengthen the weakness, right? We heal the weak, we go through the process of getting it healed and stronger. So be blessed, be encouraged, and I will see you soon. Oh, and for those of you that just started your first class with me, I've gotten a couple emails saying you dropped me out of the class. I'm like, I can't drop people. Class hasn't started yet. So anyway, if you're having any tech issues, please, and I've already reached out to the tech department. Please, if you're having any tech issues because for whatever reason you're not in the class, I can give you a permission number, but and I don't mind doing that, but it sounds like there's a heavier tech issue than that. And I've only had one student reach out to me for this, so I don't want it to sound like this is a massive situation, but things happen, dates change, things change, it's technology. So please know that nobody can be dropped out of classes that haven't started yet. Well, you can drop yourself, but I'm not going to drop you, okay? You have to get that first assignment in all my classes in order for us not to drop you, because we have to in that situation. But we'll talk about that next week, okay? Be blessed, be encouraged, and I will talk to you soon.